This event is entitled The Right to Life versus Nuclear Weapons, a bold intervention by the UN Human Rights Committee. And today is the 70th anniversary of the adoption of the Universal Declaration of Human Rights. So it's a very appropriate occasion to discuss the new general comment on the right to life adopted by the United Nations Human Rights Committee on October 30th of this year. Now, I'm going to pass around paragraph 66 because we're going to go through this word by word. So it'll give you something to look at. Concerning this office, we will need to be out of the office by 3:15, but we shouldn't hold side conversations out in their working area. So this is our space. This event is sponsored by my organization, Lawyers Committee on Nuclear Policy, and the Sorensen Center for International Peace and Justice at CUNY School of Law. As I've said, I'm John Burroughs, the Executive Director of Lawyers Committee on Nuclear Policy, and I'll be moderating. Camille Massey, the Executive Director of the Sorensen Center, is here as well. Say hello. Thank you for being here, Camille. Now, let me say something about today's speakers. After they have all presented, there should be some time for discussion. Roger Clark is Board of Governors Professor of Law at Rutgers Law. Roger is a distinguished international lawyer. I remember well his striking argument on behalf of Samoa in the oral proceedings in 1995 before the International Court of Justice when it considered the legality of threat or use of nuclear weapons. More recently, I had the great pleasure of serving with him on the legal team for the Marshall Islands in its nuclear disarmament cases in the International Court of Justice. He will give an overview of the Human Rights Committee and the general comment, in particular its paragraph 66, which addresses nuclear weapons and other weapons of mass destruction. There you are. Ariana Smith is a law student at CUNY School of Law and a Sorensen Center Fellow. This fall, she was an intern for Lawyers Committee on Nuclear Policy. She did some excellent research and analysis for me on the legal status of threats of force, especially nuclear force. Since threat figures in paragraph 66, I asked her to speak on that subject today. Peter Weiss is President Emeritus, Lawyers Committee on Nuclear Policy, President Emeritus, International Association of Lawyers Against Nuclear Arms, and member of the Advisory Board for the European Center for Constitutional and Human Rights. It is particularly fitting that Peter speak today for at least two reasons. One is that he was a central player in the Civil Society World Court project, which helped bring the question of threat or use of nuclear weapons to the International Court of Justice in the 1990s. A second is that he's a pioneering human rights lawyer. Notably, with Rhonda Copeland, he brought the path-breaking case Florida versus Peña-Arroyo. The 1980 decision of the Federal Second Circuit of Appeals established the right of foreign nationals to sue for violations of human rights in U.S. courts under the 1787 Alien Tort Claims Act. Torture was the violation in Florida committed against a Paraguayan citizen, Mr. Florida, by a Paraguayan official. The case was the basis for many subsequent and important lawsuits.
But no more.
No more? Well, that's a subject perhaps for another day.
That's a whole symposium, yeah.
Supreme Court screwed it up.
Yeah, I understand. Roger will go first, then we'll go to Ariana, then to Peter, then we'll have discussion.
Thanks, John. Thank you so much for coming to today. These sort of anniversaries, like the 70th anniversary of the Universal Declaration's adoption, are occasions, I think, both for nostalgia and for some reflection. I must confess, if you'll bear with me, that on the nostalgia front, I first gave one of these 10 December speeches back in New Zealand in 1965. At the time, I was quite a young law teacher. I was also the chairman of the recently inaugurated New Zealand section of Amnesty International. And I realized, thinking back to that time, it was also the year in which I had my first publication in a scurrilous little left-wing magazine, and it was called The Illegality of French Tests in the Pacific. Looking back at it, I wish I put the word nuclear test, but everybody knew what I was talking about in that context. It was also the year in which I was quoted in a newspaper about the illegality of New Zealand's complicity in the Vietnam War. Sad to say, all those issues are still with us, and I'll manage to drag them all into what I'm about to say in the next 25 minutes or so that John gave me for this. Because on the reflection side of this, I'll address basically two main themes exemplified by the Human Rights Committee's general comment. May I add that in 1965, when I first spoke on Human Rights Day, the General Assembly had not yet adopted the Covenants on Civil and Political Rights. It wasn't until 1966 that they did that. And the notion of a general comment was something that I, like everybody else, hadn't a clue about, nor did I anticipate over the next decade or so how practice in relation to general comments would develop. At all events, one of the ways in which I want to talk about this is the way international law and the practice of bodies like the Human Rights Committee develop by accretion and cross-fertilization from discrete areas of material. Think of the following remarks as a sketch of the intellectual history of the ideas on nuclear weapons that find themselves in General Comment 36, adopted, as is the committee's practice, by consensus earlier this year. Nuclear weapons, I've always thought, are dangerous to human beings and other living things, to say nothing of the survival of spaceship Earth itself. How does one analyze that in legal terms? How do we put that into legal language? It's the first thing. My second theme is institutional, or as I used to say, institutional. I've been in the United States too long, it would seem. My second point is institutional. The proposition is that if someone sets up a constitutional document, whether as a structure for government or as, say, an international Bill of Rights, which the Covenant is part, it will take on a life of its own, both procedurally and substantively. This is especially true if one devises a body like a court or a committee to supervise the instrument in some way. That body will get creative and develop the instrument in ways the founders may never have dreamed of. If you build it, they will come. As somebody else said, Article 6 is the first substantive provision in the Covenant on Civil and Political Rights. Its opening paragraph states succinctly that every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. Perhaps indicating the preoccupations of the drafters, this paragraph is followed by 4 wordier paragraphs cabining in the exercise of capital punishment. This is the 3rd time that the committee has addressed the right to life. In its page and a half, comment number 6 of 1982, it insisted abstractly that the right to life is a right which should not be interpreted narrowly, that war and other acts of mass violence continue to be a scourge of humanity and take the lives of thousands of innocent human beings every year. That the protection against arbitrary deprivation of life is of paramount importance. That states should take specific and effective measures to prevent the disappearance of individuals, and it encouraged progress towards abolishing or limiting the application of the death penalty. Adding to this, in its general comment number 14 of 1984, entitled "The Right to Life and Nuclear Weapons," the committee discussed the dangers of nuclear weapons. It then offered some suggestions in language much less emphatic than were to occur in general comment 36. Let me just read a couple of those paragraphs. The production, testing, possession, deployment and use of nuclear weapons should be prohibited and recognised as crimes against humanity. The committee, accordingly, in the interest of mankind, calls upon all states, whether parties to the covenant or not, to take urgent steps unilaterally and by agreement to rid the world of this menace. Unlike the 1984 comment, which related solely to nuclear weapons, the 2018 version, now 23 pages, covers the whole of the committee's concerns about the right to life. It is heavily footnoted, 281 footnotes. You're looking at a man whose kids gave him a book on footnotes for Christmas. So I love reading footnotes, and the footnotes to this document are a delight for a person like me. Comment 36 sources its content to other general comments, its concluding observations on state reports, its views expressed under the optional protocol to the Convention, other human rights, environmental and law of war treaties, material emerging from other treaty bodies, material from the UN General Assembly, the World Health Organization, the European Court of Human Rights, the Inter-American Court of Human Rights, the African mechanisms on human and people's rights, instruments produced under the auspices of what is now the UN Office of Drugs and Crime, special rapporteurs and other mechanisms, the ICTY and the ICTR. Cannibalism of other instruments is rampant in this document. The comment begins with some general philosophical points. The right to life is described as the supreme right from which no derogation is permitted, even in situations of armed conflict. It is most precious for its own sake as a right that inheres in every human being, but it also constitutes a fundamental right whose effective protection is the prerequisite for the enjoyment of all other human rights. Now, its content can be informed by other human rights. The right to life, reiterating what it said in 1982, is a right which should not be interpreted narrowly. Comment 36 also contains detailed provisions on abortion, safeguards surrounding assisted suicide, safeguards on the imposition of the death penalty, enforced disappearance, special protection for the lives of children, environmental degradation, climate change, and unsustainable development, and use of force in armed conflict, including autonomous weapons system. The comment concludes with the striking proposition, new in the context of Article 6, that states parties, and I quote, engaged in acts of aggression as defined in international law, resulting in the deprivation of life, violate ipso facto Article 6. There, I promised to get the Vietnam War in there. The part of comment number 36 dealing with nuclear weapons you should all have in front of you, and I won't read it, but I'd like to go over some of its provisions with you. Each sentence packs several ideas together. Everybody has it, right? Good. All of them have intellectual antecedents. The first sentence opens with the reference to threat or use of weapons of mass destruction. Weapons of mass destruction seems to have been coined first as a way to describe the massed bomber attack which destroyed Guernica during the Spanish Civil War. That usage solidified in the very first resolution of the United Nations General Assembly in 1946, which created a commission, and I quote, to make specific proposals inter alia for the elimination from national armaments of atomic weapons and all other major weapons adaptable to mass destruction. The emphasis here was on nuclear weapons, although biological and chemical ones were clearly encompassed also. General Comment 36 in this context contains footnote references to the later treaties of 1972 and 1992 on bacteriological and chemical weapons. Weapons of mass destruction has substantial rhetorical force, but it would, I suggest, not amount to a legal term of art. Threat or use finds its origin in the question asked by the General Assembly in requesting the advisory opinion on nuclear weapons, which has already been mentioned, from the International Court of Justice. The court insisted in its response that, and I quote, if an envisaged use of weapons would not meet the requirements of humanitarian law, a threat to engage in such use would also be contrary to law. Threat does not, on the other hand, appear in the Rome Statute of the International Criminal Court, or, in spite of some desultory discussion during the drafting, in the crime of aggression, which became part of the court's statute in July of this year. When, however, in 2017, the Human Rights Committee was preparing its first reading of General Comment 36, threat was seating itself in the Treaty on the Prohibition of Nuclear Weapons, the TPNW. The committee placed threat in brackets at that point, and several commentators, including John, supported the removal of those brackets. The reference to indiscriminate effect is to the laws of armed conflict, of a nature to cause destruction of human life on a catastrophic scale, is also an echo of the similar thought in the 1899 Hague Convention. Respect for the right to life combines the thoughts of Article 6 of the Covenant with Article 2's reference to respecting and ensuring the rights in the Covenant. Incompatible, as used there, is a stronger statement than the International Court of Justice's proposition that nuclear weapons are scarcely reconcilable with the laws of armed conflict. The assertion that the threat or use may amount to a crime under international law, may amount to a crime, is both tentative and ambiguous. Unlike, for example, the General Assembly resolution in 1946 that asserted bluntly that genocide is a crime under international law, the word here is may. Does may mean that some cases are crimes and some are not? Or does it acknowledgement the law is not quite there yet? And is the reference to individual criminal responsibility or to some notion of state criminal responsibility? Note also in this respect the ambiguity that it had not been possible to include a prohibition of the employment of nuclear weapons in the Rome Statute. The second sentence of the paragraph begins by addressing non-proliferation of all weapons of mass destruction, not only nuclear ones, and to measures which all parties of the Covenant must take. The footnote refers to the 1968 NPT, the Comprehensive Test Ban Treaty, the TPNW, and the Biological and Chemical Weapons Conventions. The little phrase, including measures to prevent their acquisitions by non-state actors, is a direct use of non-state actors, which is probably a blunter version of the prohibition treaties transfer to any recipient whatever. The obligation to refrain from developing, producing, testing and the like is essentially the list of prohibitions in the TPNW. The obligation to destroy existing stockpiles goes beyond what the nuclear powers have accepted and is a bone of contention for them. The reference to taking adequate measures of protection against accidental use sits a little strangely with an obligation to destroy existing stockpiles, as does the phrase, all in accordance with their international obligations. Is this a reference to customary obligation enshrined in the comment? Or do different parties to the Covenant have different obligations depending on which weapons treaties they have ratified? The third sentence contains two thoughts. One is that parties must also respect their international obligations to pursue in good faith negotiations in order to achieve the aim of nuclear disarmament under strict and effective international control. I take it this is a reference both to the treaty obligation under Article 6 of the NPT and the corresponding customary law obligation to the same effect, which is asserted in the Nuclear Weapons Advisory Opinion. The nuclear powers have failed dismally in fulfilling that obligation, and to my great regret, the effort by the Marshall Islands to enforce that obligation in the International Court of Justice was rejected by a bare majority of the court on procedural grounds based on jurisprudence that is frankly incoherent. I know of no other way to describe it. The other point made in the sentence is the obligation to afford adequate reparation to victims whose right to life has been or is being adversely affected by the testing or use of weapons of mass destruction in accordance with principles of international responsibility. Victim assistance and environmental remediation are important aspects of the TPNW, but this is not where the footnote in this sentence refers. Rather, it cites the committee's 2015 concluding obligations regarding, you guessed it, France. The relevant section in the observation notes that some 98.3% of claims relating to damage suffered during the French tests in Mururoa and Pangatuafa have been rejected. 98.3% rejected, and speaks of something more effective being offered by France. Article 6 of the TPNW speaks of assistance to those under a state party's jurisdiction who are affected by the use or testing of nuclear weapons. This is exactly the situation of the inhabitants of French Polynesia. The comment's term reparation is perhaps a little stronger than the TPNW's assistance, and victims would surely include people in neighbouring states or those involved militarily in testing activities. Keep that thought about the French concluding observations as I turn to my procedural theme. Article 40 is the enforcement provision in the Covenant. It requires states parties to make reports which to be examined by the committee. The committee is empowered to make general comments. General comments, as the Covenant was being finalised in the mid-1960s, was consistent with the human rights practice of the United Nations at the time. With a few exceptions like South Africa, name no names. Some general themes, the thought was, could be drawn from the state reports, and some general comments could be made. Pretty soon, those pesky NGOs began to slip in material or counter reports to government reports. And guess what? Members of the committee read that material, and the whole thing became quite a significant cottage industry. It took a few years, but eventually it was accepted that members of the committee could make some quite specific comments to quite specific states about the contents or the omissions in their reports. Don't you love the bland title that emerged? Concluding Observations. Concluding Observations. That's what the French got about their victims' assistance. Meanwhile, general comments, Cap G, Cap C, took on a life of their own. This is demonstrated dramatically by General Comment 36. The committee had begun the process of drafting it in 2015 with a half day of general discussion in which governments and NGOs participated. After that, it must have received much informal input. It then produced a first reading draft in July 2017 and invited comments. The response was stunning. I counted on its website 23 comments by states, 7 by UN organisations, specialised agencies and experts, 33 by academics and other professionals, 3 from national human rights institutions, and 107 from NGOs. How else to describe this than a massive legislative lobbying effort? Many of the comments were single issues ones, like those that Daniel Rydecker and John Burroughs prepared for the International Association of Lawyers Against Nuclear Arms and the Swiss Lawyers for Nuclear Disarmament, which obviously focused on what became paragraph 66, or submissions pro and con the right to abortion. New Zealand argued persuasively, I thought, that as a result of the development of the law, capital punishment should now be regarded as per se contrary to the prohibition of torture and of cruel, inhuman or degrading treatment or punishment in Article 7 of the Covenant. Others, especially governments, addressed a whole range of themes. The United States submissions, for example, covered 20 single-spaced pages. General Comment 36 emerged then in its current form, a true committee job. A final thought. What legal weight has the comment? As the considered opinion of the body charged with the supervision of the Covenant, it must have some significance. Words like authoritative and authentic interpretation come to mind. Comments must be a standard against which individual state reports can be assessed by committee members. Most players in the Comment 36 drama avoided such epistemological issues and concentrated on their specific points. Yet the United States took the offensive. It challenged the authority of the Human Rights Committee to adopt some parts of the general comment by arguing, it's a great quote I think, states parties to the ICCPR have not given authority to the Human Rights Committee or any other entity to fashion or otherwise determine their treaty obligations. Many of the committee's more ambitious opinions appear to reflect an attempt to fill what it may be considered to be gaps in the reach and coverage of the Covenant. It is for each party to decide for itself, as an exercise of its sovereignty, whether it were bound by what are, in fact, new treaty obligations. A British academic surveyed the jargon used in the spectrum of views on the legal relevance of the comments. And I can't help reading this to you. It's a wonderful piece of academic writing. Some commentators attach no legal value to general comments or regard them only as valuable indications of the content of rights and the steps state parties could or should undertake to ensure implementation as useful signposts or as important aids for interpretation. I'm leaving out the footnotes because she footnotes. According to others, general comments have practical authority. I like that, practical authority, because they represent an important body of experience in considering matters from the angle of the respective committees. Many commentators, however, accept that general comments have considerable legal weight. They suggest that a committee is the most authoritative, there it is, authoritative interpreter of the treaty it monitors. They view the treaty's output as more than mere recommendations. Some even regard general comments as authoritative interpretations of the rights of the treaty. General comments also contribute to the formation of international law by helping to shape opinio juris and state practice. Friends, don't you love obfuscation? Thank you.
Yes, I should have said, we're going to post remarks of all the speakers on our website later this week, as well as video. Please, Ariana. Thank you, Roger.
Thank you. So I'd like to first begin by expressing my gratitude for being here today and my inclusion on this panel. As a law student currently intensely committed to wielding the law to make a safer, better world for everyone throughout my career, I'm honored to be here with my two esteemed co-panelists discussing this recent general comment on the right to life. So while opinions may differ, as Roger was describing, on just how the committee's general comments might affect the development of international legal norms, it's quite clear that the recent comment complements a pre-existing customary norm prohibiting not only the use of nuclear weapons, but their threat of use as well. The comment reflects many similarities to the interpretation of the legality of nuclear weapons offered in the International Court of Justice's advisory opinion. In that opinion, the court said that the use or threat of use of nuclear weapons would be illegal in scenarios where such envisioned use violated international law, particularly humanitarian law. The Human Rights Committee now, in paragraph 66 of its new comment, uses language that supports the development of this customary law prohibiting the threat or use of force by asserting outright that such threat or use of nuclear weapons is incompatible with respect for the right to life. This right to life affirmed by the comment also relies heavily on the same humanitarian law-based rationale referred to by the ICJ decades earlier. As international humanitarian law encompasses principles like necessity and proportionality, as well as, importantly, distinctions between civilians and combatants, it's very difficult to envision a scenario in which either the use or threat of use of nuclear weapons could be condoned under international law. The comment takes very seriously states' obligations under our current regime to protect people from the effects of nuclear weaponry and also to pay reparations, as we heard earlier, to survivors of prior nuclear attacks and testing. Coming on the heels of additional developments in our legal framework, like the Treaty on the Prohibition of Nuclear Weapons, the new comment, I think, has potential to offer strong reinforcement of the customary norm against the use or threat of use of nuclear weapons. The consequences of nuclear force, even through targeted and tactical weapons, are too massive, too permanent, and too indiscriminate to warrant any lawful use or threat. The Human Rights Committee maintains this gravity in their comment. Neither the impact of a nuclear weapon nor its lasting radiological effects distinguishes between combatants and civilians, an essential requirement in humanitarian law. While the ICJ abstained from holding that nuclear weapons are by default so indiscriminate as to always violate humanitarian or other international law, the court did unanimously agree that if such use violated humanitarian law, it would be de facto unlawful. A little ambiguous, but it's there. The Human Rights Committee now maintains what the ICJ originally said in its advisory opinion, that nuclear weapons cause untold human suffering and indescribably harm generations to come. The comment goes further, though, in affirming that nuclear weapons intrinsically violate this right to life, and so the committee thus, a bit more readily than the ICJ, suggests the obvious. The threat or use of nuclear weapons cannot be lawful if we are to claim a fundamental respect for life within our global system. The general prohibition of force codified in the UN Charter concurrently prohibits the threats of force, too. The text of Comment 36 likewise blends these two prohibitions, stating that the threat or use of nuclear weapons, weapons of mass destruction, in particular nuclear weapons, is incompatible with respect for the right to life and may amount to a crime under international law. As such, when considering how the comment reinforces this customary norm against threats of nuclear force in particular, it's really important to define what constitutes a threat. So, while notoriously difficult to pin down, generally, the consensus is that a threat of force comprises an express or implied credible assertion from one state to a target state of readiness to engage in force should the targeted state trigger a particular condition. Usually this is within the context of a dispute. While an ongoing dispute makes the identification of a threat easier, as analyzing credibility and rationality in this context tends to be more straightforward, a threat can be made, an unlawful threat that is, can be made independent of any prior dispute as well. Credibility can present a particular challenge in identifying unlawful threats of force, but the analysis is arguably simplified for threats of nuclear force specifically. Credibility of a threat generally involves two elements: capability and rationality. An actor threatening force must have the ability to exert such force, and following through on the threat likely needs to make some rational sense for the threat to be deemed credible, and thus possibly unlawful. When it comes to nuclear threats, however, the two elements can largely be distilled into one: capability alone, as I would argue there can be no legitimate rationality in threatening such cataclysmic violence. Whether it seems reasonable to threaten force can be subjective and hard to pin down, but with nuclear force, it's really a moot point. It's never reasonable nor rational to threaten with a nuclear weapon, particularly in a world where, as this comment affirms, the right to life is non-derogable and should be construed broadly. To that end, if a state has nuclear weapon capabilities, or the active backing of a nuclear weapon state, nearly any threat of force should be deemed credible and legitimate enough to be classified as illegal. Some assert that an inflammatory speech alone, for example, might not constitute a legitimate and credible threat. But when an incendiary speech by a leader of a nuclear weapon state intimates nuclear force, the threat is credible enough to constitute unlawful action. For example, many people, rightly so, took President Trump very seriously when he threatened the total destruction of North Korea in his speech at the General Assembly in 2017. As a reminder, in this speech, Trump said that if the United States, quote, is forced to defend itself or its allies, we will have no choice but to totally destroy North Korea. North Korean Foreign Minister Ri Yong-ho responded that targeting the United States mainland with North Korea's rockets would be inevitable after Trump's remarks. Both of these leaders' words constitute dangerous and unlawful threats of nuclear force. While issued in the context of provocative speeches that some wrote off as continued political posturing by two of the world's most volatile leaders, as threats of nuclear force by two nuclear-capable countries, their credibility is established, regardless of how rational their words seemed. Again, the indiscriminate gravity of nuclear force makes threats of this kind inherently more dangerous, regardless of variations in perceived credibility. Some find that threats in self-defense offer a slightly different opportunity to consider whether a threat of nuclear force is ever legal or strategically appropriate. Many scholars assert that if a threat contributes to averting actual force, then it is or should be lawful. The force envisaged in threats of self-defense, though, must still meet the principles of necessity and proportionality and comply with international law generally if they are to be lawful. The ICJ also takes the position that proportionality must manifest as an expression of force only to the extent necessary to stop or repel an attack. A threat of nuclear force will then always threaten to far exceed any provoking conventional use of force and likely cannot be lawful. A threat of nuclear force in response to another's first use of nuclear weapons or other weapons of mass destruction, while one could argue might be a proportionate response, still remains indiscriminate to the extent that this threat would breach international law and still violate this non-derogable right to life. So while there's more legitimate room for debate as to what constitutes a lawful threat of conventional force, I argue that a threat of nuclear force is never lawful when held accountable under the international humanitarian law, regardless of whether the threat is issued from an offensive or a defensive posture. The Human Rights Committee's revised general comment and its emphasis on this broad and essential right to life for all people reinforces this notion and will hopefully be wielded as a tool moving forward to promote effective disarmament and the eventual legal prohibition of nuclear weapons. Thank you.
Bravo.
Thank you, Ariana. Can you move the microphone? And now, Peter.
I hope you will indulge me if I remain seated. It's something that will help me in making my remarks. Those of us who were around a quarter of a century ago, when we campaigned to get nuclear weapons before the International Court of Justice, and it was when I first met Roger Clark, because he was there for the same reason. Those of us who were there at the time will recall that it was not easy. In fact, it was rather difficult to get the word threat into the question that we wanted and succeeded in putting to the International Court of Justice. And as you have just heard from both Roger and Ariana, threat is not an easily defined term. So, and I'm repeating in part what you just said about President Trump and North Korea, but when he talked about raining fire and fury on North Korea, was that a threat, or was that one of the hyperboles that our president is so fond of? And to complement what the president did, we can also look at what Kim Jong-un was saying and doing about his missile capability. And it reminded me of a story once told to me by Selig Harrison, that great North Korea academic expert, when he said that he decided to take a fairly high North Korean official to lunch. And in the course of that lunch, his lunch partner said, "Do you know that we now have the capability to hit New York City?" And Selig Harrison said, "If you'll forgive me, I don't think that's a correct statement." To which his lunch partner replied, "All right, then we'll hit Chicago instead." So what was that? Was that a threat, or was that a joke? So a threat is not easy to define, and I would like to make a small contribution to that definition. And it takes the form of referring you to Article 120.14 of the Penal Criminal Law of New York State, which reads in part as follows: a person is guilty of menacing, please remember that word as I go on. Menacing. A person is guilty of menacing in the second degree when he or she intentionally places or attempts to place another person in reasonable fear of physical injury or actual serious physical injury or death. By displaying a deadly weapon. Now, is that not the perfect definition of the head of a nuclear-armed state? So perhaps it would be a good idea to expand the discussion of the term threat to include menacing, which I have just read the definition of for you in the law, which is something that you find in the penal code of a great many countries. And menacing in that sense does not even have to be limited to situations threatening the right to life. It applies to any situation in which a nuclear-armed entity finds itself in conflict with another entity, regardless of whether such use is justified by self-defense or, I have this next word in quotation marks, or because I don't like it, and that word is deterrence. And you should know that laws similar to the New York law, which I have quoted to you, is found in the penal codes of a great many other United States countries. So let me now turn to the very welcome but somewhat mysterious paragraph 66 of General Comment 36 on the right to life, clause, which is Article 6.1 in the International Covenant. The reason I call it mysterious is that actually not a great deal has changed on the ground. It may even be the case, I haven't researched this, that there are fewer nuclear weapons right now in existence than there were in 1984, when the second comment, which Roger spoke about, was issued by the Human Rights Committee. So, what are the members of the Human Rights Committee doing here? What are they telling us? Are they saying we members of the Human Rights Committee or our predecessors goofed by not referring to the complete incompatibility of nuclear weapons in the 1984 version of the comment? Or are they saying that the illegality of threat or use of nuclear weapons under customary international law is clearer today than it was in 1984? Or are they intimating that threat, use, development, acquisition, etc. of nuclear weapons is so horrendously violative of elementary human rights standards that they must also be declared to be clearly illegal? Knowing that the mansion of international law has many chambers, I would say it's a bit of all of the above. But I would also add a reference to Article 38 of the Statute of the International Court of Justice, the ICJ, which, although it mentions only sources of law applicable to rulings by the ICJ, is in fact regarded generally in international law circles as applicable to every instance in which international law, in which the term appears. In other words, you're going to find references to the elements of Article 38 whenever a lawyer somewhere or a judge wants to defend his or her reference to Article 38 as a source of international law. And these elements are not complementary. They are not a bunch of things which, taken together, give you international law. But any single element in Article 38 can be a source of international law, and frequently is. And I will just quote some of the more relevant ones for you. Nuclear weapons could be said to be illegal under international custom, quote unquote, or under the general principles. I want to give you the exact quote. Or under the general principles of law accepted by civilized nations. And please don't ask me to define civilized nations. Although, if you take seriously what I've been talking about here, it would appear that countries that rely on the use of nuclear weapons are not civilized nations. And the others, the many others who consider them incompatible with international law, are the civilized ones. And the last element that I want to mention to you under Article 38 reads, "The teachings of the most highly qualified publicists of the various nations." And that I've always liked a lot, that part, because it says, in effect, that the most qualified publicists of international law, like Roger Clark now and Ariana at some point in the future, will not only be interpreters of international law, but they can be creators of international law. So it gives great opportunities for creating international law. And some of us have been trying to do that in relation to nuclear weapons for more than half a century. So the main thing to be taken away from this discussion is that Article 66 in General Comment 36 adds an absolutely unqualified, unequivocal condemnation, legal condemnation of nuclear weapons, and that this new condemnation is joining the long list of other condemnations of nuclear weapons as incompatible with international law. And I think you have heard from the previous two speakers that it must be taken as a necessary interpretation of the general comment that nuclear weapons are incompatible with international law, and that they are also more specifically incompatible with the right to life. One comment I would also make about why this is happening now, this general comment, when it hasn't happened before. And I am indebted to my wife, Cora, sitting over there, for reminding me that Christy Weeramantre, the great Sri Lankan and international law expert, has said on occasion, and by the way, Judge Weeramantre was a very active member of the organizations that we represent here. And we miss him. He died about a year ago. But this is what he said. He said the law does not necessarily change, but the interpretation of the law changes. And I think we can think of the new general comment in those terms. And before I yield the floor to the general discussion, I just want to remind you on this 70th anniversary of the Universal Declaration of Human Rights, what Eleanor Roosevelt, who was one of the creators, perhaps even the principal one, of the Universal Declaration, of what she said about human rights. She said, human rights begin in the home.
Thank you,
you.
Peter. Well, we have a half hour or so for discussion. So just raise your hand if you'd like to be called upon. I see somebody in the back of the room. Renzo, would you like to say something?
Thank you for inviting me.
Jonathan.
I would like some of the best opinions on how we can utilize this very important position to advance the cause of nuclear disarmament. What are the strategic places where it can be relevant, and how can we advance it?
I didn't hear what you said.
He asked, how can we use this general comment to advance the cause?
Can I just say a word or two about that? Obviously I'm an academic, and my main interest is in getting this kind of stuff into the books on international law and so forth, and encouraging another generation of law students to take these matters forward. I think it's a very interesting implement to put into briefs other arguments made before courts, whether they're national or international, or human rights bodies, and so forth. It's not a magic wand. There aren't any magic wands out there, but it's another important step in delegitimating the bomb, in providing an intellectual basis for that proposition. And I think it's an important step, a significant one. It's got quite a lot of weight to it.
You use that, Jonathan, in the same way that the Universal Declaration has acquired in almost everything it says the status of law, when for decades people were citing the fact that Eleanor Roosevelt at the time, in order to get the Declaration adopted by the United States, said that it wasn't necessarily binding law, but it is now through the accretion over this long period of things like Article 66.
Ariana, did you want to say anything?
I would propose a
No,
low-hanging fruit.
Jonathan, did you
Speak
want to
a
say
little
anything?
louder.
Sure. I'd just add, I think it's a really important question, particularly considering moving forward and litigating international human rights issues in courts that might not be friendly to them, particularly courts in this country. And that I would echo what Roger said, that to me it seems that the best way to yield a comment like this and additional developments is to add it to the collection of source work to cite to, and experts, if we're to take, as Peter quoted, our international legal experts as creators of international law to make persuasive arguments that will likely fail a lot of the time until they don't. And the more source work we get like this comment, the more likely that is to put a dent in the path ahead.
Thank you, Aaron. Jonathan, I'll come back to you in a sec. I was prepared for this question. First of all, real human rights is a discourse. It's been probably the most successful discourse in the world since World War II. And so we should take advantage of that and talk about nuclear weapons are contrary to the right to life. They're contrary to human rights. That should just be part of the popular discussion. And I think in some ways it's easier to understand than, nuclear weapons violate the law of armed conflict, or the obligation of negotiating nuclear disarmament is not being met. It's a simple message. Nuclear weapons are contrary to human rights. But another a more kind of specific way that it can be pursued, as Roger alluded to in a way, and that is within human rights machinery. Now, I'm not familiar with human rights institutions, but I did look this up. And so all states parties to the International Covenant on Civil and Political Rights are obliged to submit regular reports to the committee on how the rights are being implemented. That's apparently, according to information I saw, every 4 years. The committee apparently encourages civil society groups to submit a shadow report or reports. So that's in the context of the Human Rights of the Human Rights Committee. Then there's also the Universal Periodic Review that is done through the UN Human Rights Council. This concerns each of the 193 United Nations member states, although I don't know what happens when a country leaves the Human Rights Council, as the United States recently did. So the human rights situation of UN member states is reviewed every 5 years. 42 states are reviewed each year during 3 working group sessions dedicated to 14 states each. So in this process, civil society groups have the opportunities to make comments and recommendations. Now, Seth Shelden, who's running the video and is a member of our board of directors, he reminded me that the International Campaign to Abolish Nuclear Weapons has a human rights working group, and they are trying to use the Universal Periodic Review process to encourage states to sign and ratify the Treaty on the Prohibition of Nuclear Weapons. And so if anybody here wants to say anything more on how this all works, that would certainly be welcome. But I'll go back to Jonathan.
Well, the American Bar Association has a number of relevant committees, such as the Center for Human Rights itself for the ABA. There is a standing committee of the whole over 400,000 member organization. And there's another committee in the international law section. I think that if we could liaison with them and see if we could get a resolution of the Council of Delegates to encourage advancing knowledge of this resolution in the American Bar, that would have some value. There are also members in our Congress who have a history of advancing human rights as part of their core pitch to get elected, and I think it would be really worthwhile to identify them and get this on their desk. Those are two relatively low-hanging fruits that I think that would make sense.
Very good. So let's see. Let me call on you first. Yes. Yeah.
I'm Dr. Yael Danieli. I represent at the UN, the International Organization of Victim Assistance, and have worked on victims and trauma issues for as many years as I know these gentlemen. The whole field of trauma includes in its definition of trauma the word threat. And it has, and it's a huge field with very rich findings about what threat to life does. Another crucially relevant field here is intergenerational legacies of trauma. Now, I'll give you an example, concrete example, Japan after Hiroshima. The Japanese society coined what happened to victims, the atom disease, okay? And as beliefs in society go, they decided that the children will also have the atom disease. So the children became unmarriageable. Not only because the parents, the survivors, for the most part, lost their source of income. They were socioeconomically discriminated against, which in turn created the situation for the children in terms of resources. They couldn't go to good schools, right? The children who were born after, when I say intergenerational, I talk about children who were born after, not even during. Those we call child survivors. Now, so this is just Japan. I mean, the field of multi-generational legacies covers numerous populations around the world. I brought Japan as an example because this is directly related to the topic at hand, that is nuclear. I think my general recommendation is also to also recruit other professionals into the discussion. This has been a multidisciplinary commitment of superb professionals for the last 50 years. It's not only lawyers, and we have been quite effective with international criminal law, with all the provisions on behalf of victims. And we are still working daily very hard to change the laws, the ICC, etc., and bring more knowledge, expert knowledge to judges, to hopefully to learn even the notion of findings. What does you know that there's a big gap between what lawyers call findings or evidence and what science accepts as evidence. And very little has been discussed about this in a good way. So, just this is a recommendation.
All right. Well, thank you very much. Did any of you want to say anything? I would just briefly comment that the question of victim assistance has really come to the fore with the adoption of the Treaty on the Prohibition of Nuclear Weapons, and there are lawyers and others who are really paying close attention to the subject. For instance, there's Bonnie Doherty at Harvard Human Rights Clinic. There's Matthew Bolton at Pace University. So I believe it's drawing more attention. Then it's reinforced, that is further reinforced by what is in paragraph 66 that we've been talking about today.
Yeah, I had a question about, as I recall from the ICJ opinion, there was some language about the court not being able to decide when when the survival of the state was at risk, there was some discussion about that. And I've never liked that language. I'm sure a lot of lawyers have wrestled with that. And I'd love to know the opinion of the panel as to how the comment, in your view, maybe impacts or alters some of that language from the ICJ in the opinion about that specific point, if at all.
Thank you. Good question. So he's asked, did you hear? Okay.
Well, the important thing about the question you've raised is that clause in
The mic doesn't help.
It does actually, you should put it
my
down.
hearing aids draft notes. The important thing to remember is that clause does not say that nuclear weapons are legal in an extreme case where the survival of a state is at stake. It doesn't say that. It says we don't have enough information to decide that question. That's very different. It is in no way an approval. It's something that was put in there by the justices, who included, by the way, Judge Weramantry, whom I quoted before, to make sure that everything else in that wonderful opinion is understood. And so it would be better if that clause were not there, but all I can do is repeat and tell you that it doesn't say that there are situations where the threat and use is legal. And since then, since the opinion came out, as all of us here have said, there have been so many statements, declarations, and so forth, that certainly among the academic community, there is virtual approval now of the position that the threat and use of nuclear weapons is illegal, period.
I would just briefly add to that. I think my thoughts on how the comment interacts with that particular phrase from the opinion, because as I discussed a little bit before, there's a lot that the comment draws from, of course, in the rationale of the ICJ opinion and their exact language, even in portions of the comment. And it's just, I'll just say that it's notable to me that the comment is emphasizing the need for any threat or use of force to comply with international humanitarian law in all its aspects, and not emphasizing, as the ICJ did, this pocket of ambiguity they left in about the very survival of a state. So I think that the comment is helpful in steering us toward a direction where we're focusing on all the different ways that nuclear weapons do violate the law and can't be lawful.
Can I say a word or two about this as one of the advocates in the 1995-1996 decisions? As counsel for Samoa, we had a little consortium going with Solomon Islands and Marshall Islands as well. We made the basic argument that it was impossible to use nuclear weapons without running afoul of the laws of armed conflict, in particular the Geneva Conventions and their 1977 protocols and the Hague Conventions of 1907. We had what I thought of was a backup argument, but which some other members of the team thought was more central, namely that one really couldn't use them consistent with human rights law, and in particular with the law of genocide. And we had another, I thought again strong, but not the central argument about environmental law. Now, environmental law is a relatively new development. There really wasn't any environmental law when we started thinking about the French tests in the Pacific in the 1960s. Really wasn't till the 1972 Stockholm Conference on the Human Environment that one could get some kind of global statement about that stuff. Indeed, it was a triumph of New Zealand diplomacy in the teeth of the opposition of the nuclear powers to get that. So all those packages that we thought pointed inexorably to the proposition you can never use it. Now, the problem is, at least since the 1860s, there have been treaties out there that talk a good game, and they talk about awful weapons and so on. And then you look at the operative paragraph of it. After they make the big statement of principles, they say, for example, you can't use explosive weapons under a certain size. You can have a dirty, great big weapon that blows up and shrapnel goes everywhere, but you can't have one that explodes inside a particular person. You can't use asphyxiating weapons, but the nuclear powers say, well, nuclear weapons don't asphyxiate you, they liquidate you or blow you to smithereens, but that's not what the law prohibits. So well, you can see the problem. We thought the general principle was, and three of the judges bought that. Weramantry, of course, and Shahabuddin and Judge Karoma. Weramantry, I always felt, wonderful man and a good friend, had written his opinion before he listened to the argument. The other two actually listened to the argument and they incorporated what we said, which I thought was rather good, actually. But putting that aside, there's three at that end, and there were 14 judges there. One that we thought was a sure vote had died just before the argument. Otherwise there were in 15. That left 14. And there were three at the other end who were unsympathetic to us, the ones from the United States, United Kingdom and France. And Japan, for God's sake, the Japanese judge was a judge whose basic approach to life was, we don't want to decide this case unless we absolutely have to, and this isn't really one that I want to decide. The basic Japanese position was pro capital punishment. There's a Freudian one. Was pro-nuclear weapons, but they did bring along the mayors of Hiroshima and Nagasaki to present a slightly different position. So there are three at that end, and maybe four if you count the Japanese judge who really doesn't want to decide it. And you're left with a little spectrum of people in the middle. And writing an opinion for a large court like this, where you've got a spectrum of views, is a real art form. And I think it's fair to say that the president of the court, the Algerian judge, wanted to try to stake out something in the middle there, and that was the best he could come up with. And I think it's really unfortunate that we've got the paragraph. I mean, generally, nuclear weapons are illegal. Well, generally, what's in the detail once you go to generally, and then there's this. But if you read the separate opinions, there's again a spectrum of views about the question that Peter addressed, which is, can you, if you, let's say you're Israel with your back to the wall, and can you use a nuclear weapon in those circumstances? Well, I think the majority of the court, if you read the little pieces, is no, but I think other people would read the majority the other way, and very difficult. My fate in life has been, I've argued two cases in the International Court of Justice, and in both of them the court is split right down the middle. Right? And you know what happens in a situation like that? The presiding judge gets a second vote. And the first time around, the nuclear one, the presiding judge was the Algerian judge, Bajawi, and I think it went our way. The second time around, the French was the president, and we lost in the Marshall Islands case. Arguing before a complex body like that is very, very difficult sometimes when the views are relatively evenly divided. And there's some unfortunate stuff in there. But listen, there's some great stuff in that opinion too. It really is a masterpiece of dealing with the humanitarian law issues that a sense are great, of course, well, I think it was a success. I confess that when the doctors' organisation that was involved in the World Court Project asked my advice, I advised them it was a bad idea because we could probably get some really bad law out of it. Frankly, I'm very happy that we didn't get really bad law out of it. And we got what seems to me to be pretty good law from it, about as good as you could possibly get under all of the circumstances. But litigation is a dodgy business. You can't always get exactly what you want. Sorry, that's a long-winded answer.
Thank you, Roger. So I have remembered that there is a human rights event at the United Nations at 3 o'clock. And so if any of you are attending that, please feel free to go. And also, you may have other things to do, or you may just wish to leave. But I would like to continue the discussion a little while longer, if that's okay with those of you who wish to remain. And I'd also like to comment briefly on this important question, which is, how does this general comment relate to the 1996 advisory opinion of the International Court of Justice? And I'll just say briefly this. The court's conclusion about the disarmament obligation, which was very strong and which is found in the general comment, was adopted unanimously. The court's decision, as Roger's been explaining, on the illegality of threat or use of nuclear weapons was adopted by a split vote. And it seems to me, and sort of in accordance with what Peter was saying about Judge Wiramontry's point or his view, that the law does not change, but understanding of the law changes. That we have been seeing an evolution in understanding of the law. We saw it with the Treaty on the Prohibition of Nuclear Weapons. We've seen it in other ways. We've seen it with the Rome Statute of the International Criminal Court, and I think we're seeing it also in this general comment. Right. Anybody else wish to ask a question or make a comment? Helen.
I'm just curious, maybe you covered this, but what precipitated this comment? Is there something going on in this particular, I mean, obviously the treaty is undergoing signature, TPW, but what exactly, why do you think the committee decided at this particular time?
The question is what precipitated this general comment. If anybody here knows, it would be Roger, so.
I'll give you my hunch. One or more members of the committee decided it was a good time to proceed with this, and they set out to do it. I think it's as simple as that. Somebody thought it was a good idea.
Remember, Helen, that the general comment covers a range of issues, and it might not have been the nuclear weapons issue. In fact, I would suspect it was not the nuclear weapons issue which inspired them to take on a general comment. When in the first draft of the general comment, the discussion of nuclear and other weapons of mass destruction was really sketchy. And when I think they got a flood of comments, including from us, and they really had strengthened it by the end of the process.
Don't underestimate the random in life. Sometimes people have influence, and I'm fairly sure that, as one or more members of the committee decided it was time to go. And my hunch is that the capital punishment issue was the one that generated it significantly. But I'm not entirely sure about that. I think that was probably the tail that sort of wagged the dog. But it's a big dog at the end of the day. It covers a lot of new issues. And I'm very excited about the material in there concerning aggression. That was something we've been working at the International Criminal Court through that period. That culminated in the addition of the aggression definition to the Rome Statute last year. And this sort of picked up that material along the way. I don't know who did that. You know, there are a lot of unseen hands in this enterprise, including the ones that I mentioned in my piece, which you can find on the website. But there's a lot of stuff you can't find on the website that's going on. It's a really amazing piece of work with governments and NGOs and unaffiliated scholars and so on.
Other questions or comments? Yes, Elizabeth, you made it.
Yes, wasn't too late. I also think it's interesting that the development of the law as applied also to environmental questions. There's, I think, a group in Oregon who is bringing suits about the destruction of the environment that causing harm to future generations. And I was just thinking of that when this lady was talking about Hiroshima and Nagasaki, about thyroid cancers in children developing after Chernobyl. I mean, there's a number of implications that I think is interesting that this brings out. And so I'm very encouraged to see this Article 66.
Okay, thank you.
Could I just say a word about that?
Yeah.
The Rome Statute of the International Criminal Court has a reference in the preamble to the need to do this for the sake of present and future generations. And I was one of those involved in the drafting of it. Exactly. And somebody accused me of coming up with those words. Not so. They go back to the 1972 Declaration on the Human Environment. And it may go back further, but that is a word that really emerges in the context of the environment. And I think it's really significant the way in which the general comment, if you read all of it, picks up the environmental material, as I said in my talk, and pulls it all together. Now, you know, my mind, it's sort of fun to try to put everything under the right to life. I don't know that everybody thinks that's a good idea. You know, can you enclose so many thoughts and that kind of stuff? I think it's great. But Peter reminded me about Judge Weeramantry. I once reviewed one of his books for the American Journal of International Law, and the book is called The Lord's Prayer. And Weeramantry manages to get the whole of international law within the Lord's Prayer. It's a wonderful effort. I could never pull something like that off. But again, the right to life, I think, is a wonderful thing to bring together human rights, weapons, the environment, survival of the planet, all of those things. You know, it's pretty basic, isn't it? I think you may be able to do the same kind of thing with human dignity or something of that kind too. But the right to life is a wonderful rubric, I think, for pulling so many thoughts together. And look, it develops over time. There's no question about that. It's glacial. God, it's glacial. But it does develop. And I remind you, 1965, we didn't have a covenant. And frankly, it wasn't at all clear in 1965 that we would have a covenant. 1965 was a marvelous year because the African states pushed the race covenant, Convention on the Elimination of All Forms of Racial Discrimination, through the General Assembly. And having done that was a great triumph. They said to themselves, wow, what can we do next year? And the covenants had been sitting out there since 1948, moving. Well, not even moving. They were sort of stalled. And 1966, they get a good shove. Now, of course, they have the Common Article 1 about self-determination, which was important to the African group. But it was another triumph of diplomacy to roll something that the West had seen as its enterprise, but it's sort of given up on it. They couldn't get it done. But it gets done in 1960. It takes another 10 years to come into force. The committee comes along a little bit later, and what does it do? Early on, talks about the right to life. It's the first really substantive general comment that it does in 1982, picks up the right to life. This is a culmination of a long period of, I think, intellectual growth. Put aside the procedural stuff, the way in which this has generated. Think how many more NGOs there are now than there were in 1965. I could count on my hand the human rights NGOs in 1965 that operated here at the UN. But God, it's burgeoned since then. This is a whole part of a really big process.
Thank you, Roger. I think we should wrap up. Did either of you? Okay, Bob.
What I'm struck by today, first of all, I want to thank all the members of the panel and you for presenting this, but also everyone in this room provides a hopeful sign for the future, because it's not something that is intractable. It seems to be an intractable subject, but the kind of presentations that you've all made, combined with the presence of everyone here of all generations, I think is a very important sign for the future in dealing with this topic.
Thank you very much, Bob. I appreciate that. Ariana or Peter, did you want to make any closing comments? Looks like, okay, you don't have to.
Well, my only closing comment is, if you're still not convinced that nuclear weapons are illegal under customary international law, start thinking about menacing.
So as I mentioned, we're going to have video and reports and a report and speakers' remarks up on our website, which is lcnp.org. I hope within a few days, but certainly in the next couple of weeks. And I believe that we have your email addresses, and so I will also, because you had to register for this event, so I will also send out the video and the report and the speaker's text. So thank you very much for coming today. Remember, we're supposed to be out of here by 3:15. They're doing construction apparently in the office.
Good to see you. Whereabouts? Ah, okay. Yeah. Here in New York. Yeah.
Yeah, well, you presented well. And Peter, I think your remarks came across very well, and I think everybody prepared
What's more I used to get a third one in fourth. You followed the first.
I was assisting ICC.
Yeah.
When did you get here? Yes.
Well, I was very curious.
Don't get the first about it. You just got to create it and become it. Yeah.
It seemed like whatever the system that they had was well, we didn't really need it. But for Peter, I think we're doing